Nice to see you.
Nice to see you too.
How's the United States of America?
Well, the weather is getting warmer and warmer, and well, I have air conditioner. The what is upsetting is the rising of COVID-19 in Florida. You know, it's
Right.
a new
Ordinarily, my
yes
July, I spend it in New York, Coney Island.
yes
COVID has
yeah
disrupted everything. At this particular
yes
time, I would always be at Coney Island, Brooklyn, New York,
yes.
for
Also
summer.
also in your
Apparently,
yeah.
here down here is becoming very severe winter.
Oh yeah.
All right.
So the
Thank you. Hello, Dr. Prof. Dr. Gudemela. Nice to see you
Hello,
again.
Dr. Milk. Nice to see you all again. It's
That's
really a
wonderful.
very good
How is
day.
it over there?
It's good. I mean, corona cases are really on high rise here in India.
Yes.
We are just
Awesome.
coping up with hot water and some
Yeah. Awesome. Nice to see you.
Ayurveda. Yeah, we basically follow Ayurvedic treatment and all
Oh,
the
yes.
herbs and yeah.
Oh, yes.
So
Let
how
me
is
admit the other professors right away. Professor, I can see Professor Lanciori. I can see Dr. Brenda. Hi. Hi, Professor. How are you, Professor Dr. Lanciori?
Hello,
Nice to see you.
nice seeing you
Wow.
again.
All right. I was telling my colleagues here we are in winter. Usually my summer I'm in New York. Around this time it is quite great in New York, you know, apart from COVID.
yes.
All right. Mr. Karabira,
Yes.
our counsel at the International Criminal Court. Welcome. Nice to see you.
Oh, thank you so much. Hope you're all doing okay.
Great.
Thank
How
you.
is the weather wherever you are? Where are you right now?
Hague is beautiful
Very
and
hot
sunny.
in Italy.
I see. Hi, Council Brenda. You are upside down. Oh, I'm not the only one seeing that.
I'm trying
All right.
to get.
Thank you very much. Without much ado, it's nice to have you, very prominent intellectuals in this world. We have received a lot of accolades from millions of viewers all over the world at the intellectual prowess that is being exuded. I'll hand over the proceedings, the commencement of the proceedings to Dr. Giovanni Marotta. Over to you, Dr. Giovanni Marotta.
Thank you, Professor Milton. Hi, everyone. Hi, everyone in YouTube and also in Zoom. Well, today we are going to discuss the victims and the International Criminal Court. Today on board we have Professor Alessandra Lanciotti. She is from Italy. She's a professor. Also, we have from Italy Professor Maria Mercedes Pisani, also teacher in international law. Also, we are going to have attorney Manrit Kaur. She is also a lawyer at the International Criminal Court. Also, we have attorney Brenda Ocote. She's based in Sweden. Also, Professor Rama Devi Gudemela. She's a professor in international law from India. Also will be joining us Professor Ndawarakanath Shripati, also an international professor lawyer. Also Rachel Killian from the United Kingdom, from the Queen's University in Belfast. Also Ditaba Ranchi, he is a director from the Legal Services in South Africa. Also presented us by Professor Milton, Tony Raymond, Kirabira. He also an attorney in the International Criminal Court. Also will joining us Natalia Los Coco. She's a professor of international law in Argentina, and Professor Kawame Frimpong. He also is a professor of law and former dean. He will join us from Atlanta, Georgia. Okay. Today we start with the with this with this seminar related to the victims in the International Criminal Court, and I pass to Professor MILTON to make some useful points related to the discourse of today. Professor MILTON.
Thank you very much, Dr. Giovanni Marotta. It's always a pleasure to have you co-host this intellectual program.
Thank you, sir.
I take this opportunity to welcome Professor Dr. Dwara Kanath Sripathi, who has just gotten in as you are in the process of introduction of the intellectuals in this panel. Okay, just a minute. Sorry. All right. I hope you're with me. Sorry about that. All right. Hello, Professor Sripathi. Can you hear us, Professor Sripathi? I just want to make sure everybody is on audio to get back to us in case. Okay. Professor Sripathi, Dr. Sripathi, are you with us? Can you hear us? Yeah, I think he has connection problems. We'll get back to him. All right. Dr. Sripathi, I just want to make sure I proceed. We don't leave him out on any. Are you okay? Professor Dr. Sripathi, are you with us?
Yes, yes. I'm very much here.
Oh, we can hear you now. Are you okay?
Yeah, yes, yes.
Oh, sorry about that. All right.
I can hear you.
Okay, Dr. Marotta welcomed you in your absence, I believe, and feel welcome. I'm going to make a very brief address and hand over to Dr. Giovanni, who is going to host the program. Right now, we are connected to all our viewers world over in all the 5 continents, in Europe, in the United States of America, North America, Canada, those in South America, those in Africa, those in the continental Asia and Australia. We welcome you to this very critical schedule that has been scheduled every Friday when we venture into critical international criminal justice issues that confront us on a day-to-day basis. Thank you very much for being devoted, and follow us on our platforms. Right now, as we talk, we have live streaming going on in YouTube, Facebook, and all other LinkedIn and related platforms. You may be able to follow this discourse live. I'm forever grateful to this very important panel, experts who have devoted their time to be with us at all these critical times that we've been before, and including today, to be able to share with you their expertise, some of which are personal, which draw back to the time when the Rome Conference was being held to negotiate the Rome Statute as it is today. And I'm referring to a number of my colleagues, including Professor Dr. Lanciori. It's always a pleasure to have her with us. I can see Professor Analia Fernandez getting in as well just now. I think my colleague, Dr. Marotta, will be able to take over after I'm done with the further introduction. I'm also forever grateful for other intellectuals who joined us in the process. Welcome, Dr. Analia Fernandez. Welcome to the panel. So thank you very much. Nice to see you, Dr. Gudemela. It was nice to see your contribution right from the word go. I think we are used to the hot missiles coming from the Professor Dr. Sripathi. So it was not a surprise that that continent can unleash very hot missiles, intellectual missiles. But virtually everywhere, we've had very excellent exhibition by Professor Lanciotti plus her colleague, whom she introduced to us at the last sitting. She indicated she would be held up over something, but she's with us both in spirit. She will not be with us probably today, but she's with us at following this matter, wherever she is. Thank you, Tony Krabara, who has been very active. Currently, Tony Krabara is a visiting professional at the International Criminal Court in The Hague, in the Netherlands. But as we said, all of us stand here in our own rights, and he's expressing his own views in his own right as an individual lawyer, as you see. It's nice to have Counsel Brenda also with us, or Court. She's based in Sweden, and she is here also to be able to make the usual vibrant contribution. Okay, ladies and gentlemen, wherever you are, I just wish to acknowledge one thing. The previous session that we had was very remarkable. It was remarkable in the silence in which it demonstrated the deafening silence connected to how we did not mention certain aspects of our meeting that affected the global community. That was the International Day of Justice. You know, it was a very important day with connection with the 17th of July. That is when in retrospect, if we look back, the Rome Treaty was first signed on 17th of July, 1998. So essentially, it was exactly 22 years from the time that the document was signed by 120 members who attended the conference. And that includes our own Professor Dr. Lanciotti, who is seated there, who was personally present in those proceedings. Now, the reason we did not highlight so much on this day, and we remember it came up at a later time, we had Manrit mentioning that, and actually Professor Lanciotti herself, mentioning that she mentioned how critical this particular date was. And that was very important. The reason we did not delve into it from the start was because there's not so much really that the world has given back to those who put in so much pressure, so much work, so much, burning the midnight oil, like we have Professor Dr. Lanciotti here, who had to burn the midnight oil just to see the Rome Statute come onto. However, we gave prominence to two critical points. The two critical points were, one, welcome Manrit. Welcome, Dr. Manrit. All right.
Yeah, thank you.
The two critical points which we emphasized as a center on that day, and which I'm glad that most of you noticed, was the gender limb of our fight. The gender limb of our fight in terms of confronting impunity, and two, the children's limb of that war, which is still on. We do not have any reason, but just like Professor Lanciotti and her colleague, Professor, pardon me, I'll get back to her. Sorry, are you with me?
Mercedes Pisani.
Yeah. Thank you, Prof. Thank you for being there always for us. Professor Mercedes Pisani.
Oh, she's not here today.
I know.
She has
Yeah.
another commitment in court.
Thank you so much. I know she alerted me. Thank you very much. But thank you also for coming along. I know you're very, very busy, Professor, all of you, but you get time to come through. Okay. Like Professor Pisani indicated last time, there was not so much probably for us to be able to talk about this day in the light of what has been going on in the world and what is currently going on, which we need to confront fearlessly and without favor. Because we would have expected on a day like last Friday for everybody to celebrate, like Dr. Manrit made very clear that this was a very critical day for us. And I'm very grateful for that, Dr. Manrit. It was such a great day for us because that's the time we ought to have celebrated and said, this is the milestone we have attained. Exactly. But all we have is we have states imposing embargoes, imposing visas against the very institution that they signed the agreement in. That's a debate for another. Against that background, ladies and gentlemen, I want us to recognize that since the fight against impunity was launched way back during the military tribunals, during the international tribunals for the former Yugoslavia, for Rwanda, there has been a remarkable moment for us. Remarkable in the negative, in the sense that the world's attention has now been drawn to the heinous, egregious, atrocious offenses, crimes that have been committed by people who think they can solve solutions by committing those crimes. We have lost millions and millions around the globe. In 1994 alone, during that period prior to that, the Rwanda genocide, we lost close to 1 million people within a space of a couple of weeks. So I want to seize this opportunity for us as a center to be able to express our solemn concern about the trend in which people continue to be butchered under crimes against humanity, crimes, all kinds of crimes under Article 7 of the Rome Statute. I want us to take a moment of silence in recognition, not just of those who have died owing to being victims of these heinous crimes, but also who have died fighting to be able to defend the rights of those who are fighting them. And lastly, we want also to include those who have died of COVID-19 during this time, when they're supposed to be in, they're gallantly out at war, like my colleagues with me here, they're gallantly out at war against impunity at a time when we are losing, we have lost a lot of people due to COVID-19. So I'll just request that we stand in solemn solidarity for about 60 seconds in honor of those who have passed away as a result of that war and those of COVID. Thank you. Thank you. Okay, having done that, thank you very much for joining that solemn demonstration of solidarity. Today, we are going to deal with the victims and of the crimes of heinous crimes, but also because there is an imminent important issue right around the corner, the election or the nomination of the new ICC prosecutor, sorry. We are going to have a chance to talk briefly also about the procedure for the election or nomination of a ICC prosecutor, because it's our role to be able to carry out capacity building. You'll be surprised that some of our presidents may not even know how the ICC prosecutor comes into office. So we have a responsibility, ladies and gentlemen, a big one, to be able to discuss this. I'll hand over back to Dr. Marotta, but I'll see how you'll allocate the time so that there'll be at least 20 minutes for our intellectuals to be able to talk about, to update. Actually, what we intend to do, we'll be having updates in every meeting, the first 20 minutes, updating the world on what's going on at the ICC, critical issues that are affecting international criminal justice world over, before we plunge into our usual discourse. So with me, I'll just leave with one point. I'll indicate that currently, at this point, before I hand over to Marotta in just 1 second, the ICC has been through the process of coming up with the prosecutor, the new prosecutor of the court, whose tenure ordinarily runs, as we all know, for 9 years. And the process usually goes through the process of consensus, where consensus means there will be some kind of meeting of the minds among the state parties on who should be the next prosecutor. Failing that, absent which the matter proceeds at some point to the elections. But I won't go into details. I just want to say that at the moment, the latest update is that we have 4 nominees currently who are out for appointment for that post. And there are a lot of other things that have come up, which I think my other colleagues are going to touch on, the eminent professors, distinguished professors with us here. So we have, right now, we have candidates. One is from Uganda, as you all know. We are not advocating for any candidate at this point. Actually, there's a point the involvement of the civil society is going to be given prominence in this process, as you know. But for us, as a center, we're just mentioning to highlight and to be able to bring the world into the know Uganda, we have, Uganda has been very active, you know, in the issues of, you know, the ICC, the Rome Conference, the review, as would be testified by our colleague, Council Tony. Dr. Marota calls him Council Tony. I like that. So we have a candidate from Uganda, and that is, you know the name, you give us the name. Obviously, you must be knowing the candidate for the ICC prosecutor. Council Tony?
Okay, it's Judge Susan Okalany.
Absolutely.
Yes.
There's a judge. She understands. We don't have to talk because they might think you're advocating for her. Just mention the name. She is a judge of that court at home, has been through the appellate jurisdiction, and she has demonstrated some, you know, expertise that area. That's why they were nominated. Then we have, that is from Uganda.
Yes.
Which is the other one? Somebody wants to step in for me. It's not a class. We're just discussing. Obviously not Karabira. Okay, from Nigeria, we have also a candidate, but he is based in the United States of America. He's had his private practice, and from the information I get is that he's had a very excellent practice, and is also vying for appointment. His name is Maurice Anya. Maurice Anya. Then from Ireland, within the Great Britain, within that island, we have Figal Gaynor. Figal Gaynor is another candidate. And finally, from Canada, we have Richard Roy. So that's all I need to say. I don't want to go into details because that was not part of my agenda. I just wanted to indicate every time we give highlights to our audience, in their millions, they're actually very keenly watching. And so they now know we have 4 nominees for the prosecutor. These persons, a very important event is going to take place. Our listeners, dear listeners, wherever you are, next week, around the last days of the next week, a lot of significant, you know, steps are going to be taken towards coming up with a prosecutor, new prosecutor of the International Court. If that step does not yield anything via the consensus approach, then we'll be left with the option of election of the prosecutor by the members of the Assembly of State Parties, which might take us now on to September. So there's a possibility after next week we'll have a new prosecutor already nominated. That failing, absent which, after next month, we'll be having the prosecutor of the International Criminal Court. And as I said, you can only step in after the current prosecutor, Ms. Fatou Bensouda, has stepped down after 9 years of tenure. Thank you for listening, ladies and gentlemen, distinguished professors of law, and thank you, counsel, who are distinguished among many. And I now take this opportunity to hand over to my very erudite colleague, Dr. Giovanni Marota. I respect you so much, sir. I hand over back to you. Thank you.
Thank you, sir. Thank you, everyone. A great introduction and update from Professor MILTON related to the new candidates. From the background, and I was reading last week from the Justice in Conflict organization, the news for many, the reaction has been a shock, you know, because of the background of many of these, the way they are proceeding. Because according to this news, there were more civil candidates, but I think that the prosecutor office is trying to make a change. I mean, it's trying to have a more agile prosecutor office. It's more active. No, because it's with Moreno and with this last administration, it has been a little bit a passive office, you know. For example, I was checking the updates of, for example, Georgia. I mean, Georgia opened a proprio mutuo investigation. It's going to be 4 years ago, and that's it. We don't have more action from 2016 related to the pre-trial from the pre-trial chamber. There, I mean, it's a little bit slow. I mean, and the alleged crimes were in 2008 between 1st of July and 10th of October. So right now we are going to have this meeting related to the victims and all the survivors of that crime. So starting from the example of Georgia, I mean, that's the new from the one of the cases that I try to pick up. This is the newest one. I will not tell the other ones. For example, in Georgia, I mean, how the court is. This will be my question. I want for the panel. I mean, from your expertise from your field. I mean, from your law practice. How do you feel Georgia is going to continue the I mean, the pre-trial, the third, I think it's the third pre-trial chamber. I don't recall it was the other trial chamber of the ICC. Is going to, what is your expectations with the new running office of the prosecutor in the ICC? They are going to handle these cases because, I mean, it's been 2008, it's 11 years, 12 years behind us, and it's have been too slow, the investigation. I mean, if you see how the ICTY handle the cases, for example, in Srebrenica or the other cases, you see there was a more active from the prosecutor office related to the investigation cases. We don't see that right now. And from my point of view, I don't see that right now in the ICC. I see it too slow. I mean, so how do you think this will have this kind of repercussion for the victims? This kind of slowness of how the prosecutor office has been for the ICC in the last 11, 12 years running. What do you think about that? I mean, from your expertise and seeing the other ad hoc previous international courts of justice as the recently ones, ICTY, Cameroon, Rwanda. Why do you and how they approach the cases and this kind of restorative justice for the victims, and how do you see it in a comparison with this finishing administration of the ICC? Anyone? Professor Shivati, I see you eager to answer.
I was actually waiting for the newcomers to come out with their views.
Mm-hmm.
I wanted them to have a chance to speak before I can speak. But hello to all the panelists.
Hello.
Good evening.
Hello,
sir.
Professor.
Good evening.
Hi, Professor.
Hi. The concept of victims' protection and compensation was absent during the two ad hoc tribunals, that is Nuremberg and Tokyo, after the Second World War. When these two tribunals were established, there was no discussion, there was no any kind of reference that was made to victims' compensation and protection. However, this particular aspect that victims must be protected and compensated for the suffering that they had undergone. And this was in 1945 and 1946, the two tribunals. Then we had the Genocide Convention in 1949. And in 1948, we had this Universal Declaration of Human Rights that was laid down by the United Nations General Assembly. So these two instruments, international instruments, clearly tell us that the victims' protection and compensation had come into recognition. In the sense, these are aspects that were now recognized by the world. But despite having these, then in 1985, I think, we had a United Nations declaration on basic principles of justice for victims of crimes. Now, this particular declaration was passed by the United Nations General Assembly, and the declaration mostly laid down four avenues for redress for victims. One is access to justice and fair treatment. That is, focus was emphasized on these four avenues. The first is access to justice and fair treatment, restitution, secondly, thirdly, compensation, and fourthly, assistance. Now, then, this declaration, as we all know, the declarations and resolutions passed by the General Assembly are not binding upon the states. They merely serve as guidelines for the governments to adopt the principles that are there in the declaration and the resolutions. Now, coming to the ICTR and ICTY, both the criminal tribunals had provisions which spoke of victims' compensation and protection. Particularly ICTY, Article 22 clearly speaks of the procedure as to how a victim has to be compensated and how protection has to be provided to the victim. So one right that was granted to the victims under ICTY was the right of anonymity. That is, when the victim as a witness is testifying against the accused, the victim has a right to remain anonymous. But however, this particular principle of anonymity was challenged by Tadic, who was the main accused in the trials of the ICTY. Now, what he said was, there are some minimum rights or standards of protection that are provided to the accused also. And one of them is to examine the witness who is testifying against the accused. So he wanted that right to be enforced so that he can see the witness, identify the witness, and examine the witness. But the ICTY refused, saying that the anonymity of the witness is more important than the right of the accused. And by deciding in this manner, the ICTY depended on a decision of the English courts in one case, that is R versus Taylor, where the English courts clearly said that the right of the accused is not paramount under certain circumstances. The right of the victim or the witness is more paramount, important. So keeping this case and relying on this case, the ICTY has denied Tadic the right of witnessing, right of examining the witness. So this clearly tells us that victims' compensation and victims' protection has now become a regular feature in the International Criminal Tribunal's trials. Then when it comes to the deliberations of the ICC in 1998, a lot of discussion went on in respect of the kind of protection that would be provided to victims and witnesses. And the ICC does consist of certain provisions, the statute of the ICC, where victims are protected and the witnesses are also given protection. Now, there are various aspects of the victim's protection, like we have restitution, where restoring the property of the victim after the crime has been committed, and then compensation. Compensation is a certain amount of money that is given to the victim, and under the ICC, a trust has been created. So all the fines that are collected by the ICC go into the trust, and probably from the trust, the victims are compensated. And this is also a very common principle under the principal legal systems in the world as far as administration of criminal justice is concerned. Even in India, we have under the Criminal Procedure Code a provision where when a fine is imposed upon the accused, that amount of fine is given to the victim as compensation. So this is what the ICC has adopted, and the provisions are there in place, and the ICC is doing its best. But in order to do complete justice to the victims, the ICC has a long way to go. And we all hope that the ICC will be successful in protecting the victims in the future. This is what I have to say. Thank you.
Thank you, Professor.
I wanted to add 2-3 lines more. First of all, I will tell who is the victim. Victims are those whose voices are oftenly left unheard, and their sufferings are always forgotten. So, under the Article 79 of the Rome Statute, firstly, I will tell the Trust Fund for Victims came into the force in 2004. ICC came in the force in 2002, and after 2 years, Trust Fund for Victims came into force. So, if we see the Rule 85 and the 86, these totally defines the definition of the victims and their general principle regarding the compensation and other facilities for the victims. So trust fund in the ICC, Trust Fund for Victims, they have twofold mandate. To implement court-ordered reparations, and second is to provide physical, psychological, and material support to the victims and their families. So Trust Fund for Victims in the ICC covers these two aspects. And if we see in the ICC, I will just conclude in 2-3 cases. In the Thomas Lubanga's case, the trial chamber has ordered Thomas Lubanga's liability of the US $10 million. He will pay to the victims. It was the amount was the $10 million US. And same in the Ahmed Al Faqi's case, 2.7 million euro trial chamber has ordered the liability. That was the liability of the Ahmed Al Faqi. And the same, if we see in Katanga's case, trial chambers has mentioned the liability of the Katanga for the $1 million US dollar for the victims. So if we see the ICC is also playing own role and doing much efforts for the victims. If we see the cases, recent cases, that's all.
Okay, thank you, Attorney Manrit. Anyone else who wants to add some of this great presentation of Attorney Manrit and Professor Shipati?
Well, that's excellent. Excellent introduction. I just would like to add my voice onto another element to this discussion. In addition to reparations and protection, the element of participation, which I think is evolving, but also very, very important. That at least participation in two ways. The way of participating in the trial and not just as witnesses, okay, but being able to participate with their own lawyers, independent lawyers, not ICC lawyers, but independent lawyers appointed by the victims. And that's pursuant to Article 63(3) of the Rome Statute, which I think has given a chance to victims, different victims, to be able to air out their views. Because like you might know, sometimes maybe the prosecutor may not be viewed as adequately representing the views of the victims. So I think that is important. However, from my own observation, and this is my personal, it is not from the ICC, of course, the defense also challenges mostly this kind of involvement. Many times the defense will allege that there's no equality of arms because they are versing a team of the prosecution and also victim representatives. But fortunately enough, most of the times the court has not accepted this submission. But more importantly for me, not just the physical participation in the trials, but we've seen for the first time in the case of Ongwen, which relates to the situation in Uganda, that the court's outreach has been able to have victims follow the proceedings from their countries, screened live on television, on huge screens in the public, which also gives the victims a sense, of participation, not just physically. So I thought that was important. Thank you.
Thank you, Professor Attorney Tony. It's funny when I say Attorney Tony. Yes, but what Counselor Tony was very consular related to the equality of arms mentioned is, but here the defense attorney of the perpetrators, I mean, they are a little bit remember from which background they have. If they are common law lawyers, they probably will challenge it that. But if they came from the civil Romanic for the civil Germanic Romanic background law system, it's normal. For example, in Spain, in Latin America, in any country from this background, it's normal that the victim, his lawyer will be in the trial. I mean, it's normal. That if you check the Chilean criminal procedural code or the Colombian, I remember that because I
So
have
the
some.
Italian and the French ones.
Yes, exactly, and the Italian, the Spanish, the French ones. You can, I mean, the victim his lawyer can be part of the process. Sometimes, depending for example, of the criminal case. Sometimes it can be the criminal action can be presented by the prosecutor, or it can be also from the victim by his own lawyer. So I mean, that's why the ICC is a hybrid system between the common law, the Romanic Germanic civil law, trying to build a new core system, because from my point of view, it's, I mean, what is challenging the prosecutor from the ICC from of the in the case is seeing the whole world as a state. You know, it's still a whole state, and it's representing the damage against the victims. And the lawyer for the victim is representing the victim, so the lawyer can remind also the prosecutor and also the judges that because that what I see here is what happens in a normal court, not in international court related to criminal law, for example, in Italy or in Spain, is going to happen also in the international criminal court. I mean, they are human. Sometimes I mean, the victims, as always said, always the victims needs their lawyer in the courtroom be to also to highlight the issues, the damages that they received during these horrible crimes. So from that kind of point of view, probably from the common law lawyers, but from a background from a Romanic Germanic civil law system, it's different. So I don't think it's a sensible way to challenge the presence of the attorneys of the victims. Hence, it's important that they have some kind of legal representation, because what is challenging as I said, the prosecutor is trying to challenge the human rights of all humanity. But in these specific cases, as Attorney Manrit, in Thomas Lubanga or Katanga, or as I started in the case of Georgia, I mean, the voices of the victim is important to be in the court also by the lawyers, because the lawyers are the one who understands a little bit better what is going on in the court. And sometimes they need, myself as a practitioner and attorney, sometimes we understand the law and we can explain what is going on to the victim, because sometimes in the court, the victim may see that the judge is not listening well, or the prosecutor is not being too inquisitive against the other lawyer related to the perpetrator. So I mean, it's important that the lawyer of the victims be present in the cases. Also, I passed the test to Professor. She was trying to Rama Devi. She was trying to also to say something.
Yeah, just an addition to what Manrit Council she has said. Victims here, I don't think so. Only individuals are included in as victims. I mean, only individuals. They are not only it is limited to individuals, but any NGOs who can represent them. I think even that organizations are considered to represent the victims here. So individual alone, if they are not in a position to go and represent before ICC, then I think some organizations can also represent on their behalf. And one more thing is that, just an addition to Counsel Tony, whatever he has said, and whatever Dr. Marota, even you have said, that three parties are given representation to represent before ICC. One is from the victim side, that is the attorney. The other one is from the accused defense, or the whoever is from the defense side, and the other one is prosecutor. So three people, three parties are representing here for one particular case. So that is there in the Rome Statute. And one more thing, I see challenges that are faced by International Criminal Court in few areas, like collection of evidence. As I have also said this in the last discussion, that evidence collection is quite a tedious task, I feel, for the International Criminal Court when the trial proceedings are going on. And another one that I wish to mention is that victims protection sir has said, Dwarkanath sir, he has mentioned saying that anonymous status of the victim or the witnesses, not victim, witnesses should be maintained here. That also is a provision and very much a part of ICC Rome Statute. But when the state itself is the perpetrator under Article 7 of the Rome Statute, like humanity violation rights or whatever other rights here relating to humanity violation, in such a case, to protect the victim also plays an important role. So I don't know how far ICC is successful in protecting the victim there from the clutches of the state. So this is also, I think, a challenge by the International Criminal Court. And another one is getting the accused arrested from the place where he is living, that is from the state where he belongs to. If the for the sake of trial, the person needs to be brought before the ICC. How even that, I think it is a challenge for the International Criminal Court. So I just wanted to ask Manpreet as to how you are dealing with these kind of challenges. And lastly, I just wanted to mention one more thing here as to with the restoration clause here in ICC or Rome Statute. Not only compensation is the remedy, or victim is not only awarded with the compensation. The word that is used in the Rome Statute is reparations. That is, it includes compensation as well as it also includes restoration. And if there are any rehabilitation that has to be given to the or provided to the victim, and in such a case health related rehabilitations or some psychological counseling related rehabilitations, so these are all which are need to be provided to a victim of war crime or humanity related crimes. So I would say that this is a wonderful clause which is put up by Van Boen at the time of drafting the Rome Convention. So I think ICC, it has certain challenges, no doubt, because every state is a sovereign state. And these are what I mean, I just need a little clarification from Manpreet, because she's a counsel there, how you are tackling with these kind of challenges. So anyone, thank you.
Thank you.
Yeah, thanks a lot. Thank you. First of all, as you are saying that individual is always a victim, but the association and the organization can also be a victim. So in a just a lighter way, now today's situation, kindly just take it as a joke, because if we see the pandemic situation, all over the world is a victim. so
Yeah,
all over the present scenario, all over the world is victim. So let's see, because so many attorneys and so many lawyers and so many researchers are trying to approach the international courts regarding this COVID-19 situation. So let's see, hope for the best. Our situation and all over the world is the victim, and hopefully we'll get something compensation from China. So
that again is a state responsibility. I understand. Yes.
Yeah.
Yeah, thank you so much. That is what I just wanted to put forth, Dr. Marota.
All right. Thank you very much, Prof. Doc, with your permission, let me just intervene a bit. Thank you very much, Professor Dr. Gudemela. That was erudite as usual. I just want to appear on a technical issue. We have Dr. Victoria Renzo in the house.
Hello.
Oh, yes. Hi, Victoria.
Nice to see you.
Hi.
One more time.
Nice to see you too.
Yes.
And once again, so
Absolutely.
happy to be here.
Thank you. Thank you. For those who are not yet versed with where her background lies, she's actually representing Canadian Institute of International Expertise. So she's here on that. She's one of them, but everybody here tries to reason from their own point of view. And of course, I think everybody else now is familiar. Okay, Dr. Marota.
Okay,
yes. I think that was good discourse. I have my point, but I want them to come late. I've seen there's very good input coming in. I don't want to preempt anything on my side, but so far it's really, really encouraging, Prof. So, okay, back to you, Dr. Marota.
Okay, Brenda was.
Yes, sure.
Yes, here is Brenda.
Yes. Thank you again for this privilege. I'm happy to be here. Well, and thank you for all the brilliant presentations from everyone who has participated so far. Well, I just wanted to add to the previous, the previous presenter who talked about the evidence selection, and mine is about, I want to get some light on the victim selection itself when it comes to witnesses, because I have heard and seen. I happen to have come from Uganda, and I was very young when the LRA war started, and I could have called myself also a victim. But when it comes to the selection of the witnesses themselves from down there, I don't know how the ICC is dealing with it, that they get the right victims to come and testify. I mean, to come to the ICC, and what are the procedures? I know that there are procedures laid out, but are they fully followed? And that we're not going to get people who are going to tell us stories or have hearsay brought in as evidence and so on, because I've already had cries, and I think up to now I still know that after the arrest of Ongwen, there are even some victims who are still lying in Kenya who were selected as witnesses from Sudan and so on. So there's quite a lot around the selection of victims and even the councils that are defending them. Are the states not involved? And if they're involved, what part do they play? And how does the ICC take it or see? Thank you.
Thank you, Brenda, for that great intervention. Anyone else related to this point of victims, about how the ICC handle the witness related to which one is the one that's going to be the right witness, as Brenda has pointed. Anyone wants to participate from their background? Don't be shy, kids.
Well, I could maybe
yes.
say something.
Thank you.
Participate.
Yes, thank you, Victoria.
Well, first of all, I like to recognize how much the ICC has advanced and improved regarding the treatment of victims, enable them to participate, invoke arguments, have legal representation, as you said before, that I think is very important. And also follow the process, offer evidence, and even demand compensation. And all this despite many states from common law question whether victims should be allowed to participate in the protection and recognition of victims in such way or not. So it's also important not affecting the rights of the accused, of course, but I think that listening to the victims, not only as witnesses, but also as parties of the conflict, can be a valuable contribution for the judge to solve the cases without implying always a positive result for victims, since it could also happen that judges, after hearing victims, could determine that the alleged damage has not generated such serious consequences, either acquit the accused or reduce his punishment. So the intervention of victims turn out to be beneficial not only for them, but also for international human law. For the ICC itself, since a procedure in which all those who are involved have participation, has a better chance to obtain a fair and efficient sentence. Also, the fact of not recognizing the victims as part of process, I think it's violating the right to be heard, which emanates from multiple international human rights treaties. And I also think that denotes the importance of this paradigm shift of the ICC and the war in general, since before the victims used to be mainly marginal groups without means to access justice. But nowadays, the COVID pandemic has shown us that we can all be victims, since its excessive spread has caused hundreds of thousands of deaths and health problems, as well as serious economic crises from all around the world. So, well, in this point, I would like to add that recently the CIFILE, which is chaired by Dr. Abbas Hashemi, has filed a complaint with the ICC requesting to open an investigation and prosecution the situation to determine if there is one or more world leaders responsible to withhold and suppress crucial information about COVID-19. The alleged crimes will fall within the jurisdiction of the ICC under Article 7 of the Rome Statute, Crimes Against Humanity. And the complaint alleges negligence regarding the information provided and the delay in communicating the viral outbreak, affecting not only global health, but also the environment, in breach of the principles of prevention, precaution, cooperation, and good faith. So this investigation could contribute significantly to the development and evolution of international criminal law, not only in terms of the participation of victims, that in this case could be a million, even any of us could be one of them, but also in terms of the implication of committing similar gross damages and the punishment that it deserves. So as the other experts said before, I think it's a big challenge that the ICC has to improve its procedure by mediating between the common law and the Romanic and Germanic system. So,
okay, thank you, Victoria. A very excellent and presentation about your point of view. You have compact everything, and also mentioned this investigation against world leaders related to the COVID-19. Yeah, because it's if we see it, it can be consider the spread of this disease like I don't know, like a biological weapon, if we can agree, if we can point it out, because it was if it's demonstrated that it was some kind of negligence, that the spread was done from not from a person eating this bad or it was spread because of negligence handling some samples from some laboratory, and they wanted to hold it. Also, what I want to what Victoria has told us about this negligence. There is a figure in the criminal law that's is named culpable negligence. Many, I think many head of states, how they react to the pandemic could be trial under culpable negligence against crimes against humanity. For example, reading the news, I bring here, for example, Ecuador, knowing that the pandemic was in February, was already a pandemic. They did nothing. The executive branch, they did nothing in their power, among all the resources, how to approach and to take care about the disease that have cost many lives. So I'm going down from South America. Peru and Chile. Chile and Peru, they both, I think first was Peru. I'm doing a research because I'm going to write a paper about this. In Peru, they start in, I think was the 16th of March. They decided, okay, we go to the lockdown. But then if you see how the disease evolves in Peru, I mean, it's a country that have the money to buy, I don't know, all the equipment to fight this disease. I don't know why the health department decided not to receive the respiratory equipment that was sent by the I think was from Israel government. Also, the South Korean government was practically given this new molecular test as a very low price. They decided not to buy it. And then I read, I think it was in the Washington Post, or was in Boomers, the data that the official data doesn't make sense with the other data that are recollected by other sources, that the toll deaths are much higher than so. And also what happened in Chile. In Chile, they decided to lock down, but then also some kind of, from the president decision from some groups, politician groups, making some pressure to open the country, and the disease spread much more of what happened in Chile. So I think under culpable negligence, and as what Victoria have told us, not only for the world leaders, but you can go on and see to a very specific countries how the culpable negligence of their leaders had made the situation go worse, and right now in some countries it's not very there are hotspots. Or for example, a hotspot, for example, in Florida right now, in Florida in the U.S. I mean, by this thing that we have here, against my freedom, if I want not to use the face mask, this kind of stupidity have made has the result that Florida is the new hotspot of COVID-19 around the world. I mean, it's every day you see in the news that the spread is going higher and higher and higher, and the pressure from the White House to reopen the schools now in September. I mean, I don't know how it's going to be handled. That and some states are okay. We are not going to make. They're going to evoke to their own state's constitution. If the federal government wants to reopen the schools, they will not go into. Okay, so now
I'm not intending to disrupt. I'm not intending to disrupt you.
No.
I just want to update our viewers and panelists about our other panelists. Okay. As indicated, Am I allowed? I can proceed?
Yes, yes,
Oh,
yes.
Thank you, Doc, as usual.
Yes.
As indicated, Dr. Mercedes Pisani is attending a court matter, as we learned from our other learned professor, Dr. Lanshoi. She's on a court matter, should have been with us, but she alerted me prior to this that she may not be able to, resolve the conflict, but she was not going to be here anyway for that matter. So that's understood. You can see that we are a bit the emeritus, the emeritus professor. He has just communicated with me. He's actually struggling to connect. I noticed a number of our colleagues was struggling to connect. There was a slight technical thing that we are sorting out, I think affected. If we have any other person that you know may be facing challenges to connect, just let us know. So we put him on board. So the emeritus professor will be with us in a moment. I can see his message coming through. So that was the second one. Who is the other one? I cut. There's one other part. Yeah, Dr. Ditaba. That is the Director of Legal Affairs, the Republic of South Africa. The one I said is a senior government officer. He's just indicated he'll be with us shortly as well. So we beg for your pardon. We seek your indulgence in this matter. Our viewers, millions of our viewers all over, will soon be joined by those three and many, those two, not three, and many others in the process. Oh, it's okay, Dr. Marota. I just had to intervene on that.
No problem.
Possibly,
thank you.
Possibly one last point on this one. We are working still on the issue of are we dealing with it, because you notice I need to apologize also on behalf of the panel for those. We brought in the issue of the ICC, new ICC prosecutor, because that was a contemporary issue that is engendering concern. So many of you may not have been in a position to look into it, but it is also one of the limbs of our discussion right now. The new prosecutor, the procedure, and how everything goes, then the victim of participation as well. So it should not appear like the panel is confusing any viewers. No, this is the way we approach it legally here. So I leave it to the very competent host, Dr. Marota. Any moment the other colleagues will come on board, I'll be able to alert you. You'll be able to see them. Thank you very much. Oh, I forgot Dr. Renzo. One of your colleagues was here as well. I think last time you apologized on her behalf, but she managed to appear. Dr. Professor Aliza. She was around.
Yes.
Yeah, so it's okay.
Yes, she had problems with the connection. She just told me.
Okay, if there's any way we can help, you let me know. Right, you can just send through the chat communication. Thank you, Doc. Thank you so much, ladies and gentlemen.
Thank you, Professor. Okay, continuing. Yes, summing up about the situation about COVID-19. Yes, I think as Victoria has enlightened us with this new information about the investigations for world leaders. I mean, from any country, if they decided to do a very due diligence investigation, they will find that under culpable negligence, some of their high leaders of the country could be tried for this kind of international crimes against humanity, because about not doing. I mean, even though I was thinking last night about joint criminal enterprise. If you find some kind of corruption related for the buying of some of these face masks or other equipments, I mean, because somehow the people have died and are they going to die. So it's very sad. Also, as I was telling before, I mean, in South America, this country I was telling about Peru and Chile. I mean, they are countries that in the last past 25 years, they have increased their economies. They have money. They could bought these hospitals that are for. I mean, if you see in the internet, there are these hospitals that they are using in conflicts, and they can put you, and they have all these all these equipments for fighting COVID-19, and countries that, for example, Chile or Peru, I've seen the news, they have a lot of infected people. Their public health system has collapsed, and I don't understand why they don't get these contracts for. I mean, and I am searching how much costs the cost of, and they have the money. I mean, and they are not doing nothing. So until that reason, I mean, probably as Victoria has enlightened us, they could be in the following years investigations and some kind of prosecutor from this health disaster that is affecting everyone around the world. Also, if this continues, also Italy can, for tort damages, can sue China, because there is, I mean, if China knew that this was started in December in the north of Italy, there are a lot of Chinese migrants. They should, SAP told the authorities of Italian authorities that there was a virus and that this was going to enter into Italy. So, I mean, as soon as investigations will deep, we are going to find what really happened about this situation that we are all immersed. I think Brenda wants to add something. Okay, Brenda, the floor is yours.
Sorry, I was muted. Thank you for the privilege.
Yes.
Yeah. Well, I'm just wondering, when you talk about the COVID-19, and then I'm wondering how the ICC is prepared then to deal with the present, okay, it's the new techniques of fighting, like the drown issues and everything. Who are going to be the victims, and how are they going to investigate it? Has it looked into it? Has it started? Because they kind of came, yeah. That is my question, and how the ICC is thinking of dealing with it.
Okay, Tony or Manrit, you guys that are right now in the field.
Okay, yes, that's really important. We see already there's progress in use of technology in investigations. To be honest, I wouldn't be able to tell you whether the ICC is using that approach or not, but at least, for example, from the case of the Rohingya in Myanmar and Bangladesh, the independent fact-finding mission of the UN that did a great job to investigate the atrocities. Of course, used a lot of that technology to document, and I was able to come out with a detailed report. So I think, in my opinion, it's really good. We need to see more of technology being used to do investigations.
Tony, I want also to ask a question. Does the ICC third parties the investigation? For example,
Hello, Prof.
Yes.
How are you? Sorry for this.
Okay, no problem.
Everybody was affected. Can you just try this number? It should go through. Because we never use passwords, but because we changed. Oh, sorry. Sorry. Let me unmute. I didn't know I was online. So sorry.
Okay, no problem, sir. That's the job.
My apologies. Let me mute myself.
I thought he was trying to say something that appeared. Okay, something is here. Okay, no, I was asking if the ICC, the prosecutor, offers third parties to, for example, I don't know, an international company that deals with investigations. Does the ICC, in some cases, third party the investigation, or they have to hire there are there proper investigators for doing I don't know, the aiding of the criminal, the CSI of the case.
The ICC is, in my opinion, at least well equipped with both permanent and consultants.
Okay.
Yes, with both permanent investigators and consultants. And but otherwise, I think it's also good to have, you know, diverse people investigating, organizations, and especially those could help from the victim's point of view if they work more with the victims. Like we said earlier, that the prosecutor is independent and
Yes.
so would not want to be associated with any other parties for that matter.
Correct. Yes.
Otherwise,
That's right.
that's a really important point.
Yes, that's true.
I will
yes,
add,
Marit.
yeah,
The floor from Marit.
ICC has their own specialist investigators, and if anybody, any complainant or any victim wants to give some research or wants to submit some documents regarding their investigation, then Office of the Prosecutor will first check out the relevancy of all the documents with all the evidences. Then they will decide this application or this submission have to be tried by the or entertained by the ICC or not. So all these things are ICC have already very well equipped technologically, and especially for the victims, the trust fund for victims, they are doing well. They are improving day by day, and they are making the situations good and helpful for the victims.
Okay, that's good to know, because I didn't know how it really works within the prosecutor office, because, for example, in some states in the U.S., the district attorney office has the opportunity to use the police or the FBI, or if he doesn't like the way they are doing, I mean, in some states, not at all. I'm bringing you, for example, in Utah, in Salt Lake City, they can hire a third party, like a PI, to do the investigations. So they can have a more, more reliable to the investigations that sometimes the sheriffs or the police can do in some kind of cases. Not in every case, but I thought that the ICC also, for example, if they have a lot of dealing with and they are short-handed, I mean, they can hire a third-party company to do all the research of CSI with anthropologists and criminologists.
Yeah,
so,
yeah. Actually, it totally depends upon the facts and the circumstances of the case or the situation. If there is a need to hire the investigator, then ICC will do. If there is also need in defense team or in the office of the prosecutor, they will hire and they will make the arrangements for all of that investigation. But similarly, as you are telling about the US, in India, if somebody wanted to start a case they will just give a complaint in written to the police station. Then the police simply investigate that matter, and they will decide if the investigation evidences are relevant. They just start the case in the courtroom. So it is normal. And if in India, a Central Bureau of Investigation, the CBI or the other investigation department works only or investigate only if the victim or the complainant especially files the application in the courtroom, they wanted to investigate their own matter, then it is possible only. Otherwise, the normal police station or police officials do their job.
Yeah, that's what I was asking, because sometimes, I mean, they probably. I was asking in the ICC. I don't know how many how many investigators they have for each case, or if they need some aid, because sometimes when you're deep in a human rights violation case, sometimes you get it in the first stage shorthanded. So it's the amount of information that arrive is unbearable. So that's what I was asking. If you, as the ICC prosecutor officer, you have like, I don't know, okay, I am shorthanded, I can, I don't know, knock the door or try to find more investigators for aiding me, or a company like a third party or an NGO that deals with this kind of investigation for aiding me. So it's good to know that the ICC has that, the prosecutor officer has that kind of
yeah, because if somebody wanted to start his case in the ICC, firstly they have to just approach the office of the prosecutor, or any victim or any complainant. If they wanted to approach their case or regarding any situation, firstly they will approach the office of the prosecutor. Then office of the prosecutor will see the relevancy of all the documents and the evidence. Then they will decide, the registry will decide this situation or this case ICC will entertain or not. Because as in our last discussion, last week discussion, as I told, ICC will entertain only if the state party, if the state country fails to handle the heinous crimes. Then,
yes, that's true. That's what, well, the cases that we have, like, for example, Georgia, from the crimes in 2008. I mean, they have done nothing. So also there is a mission of the OCCE from the European organization that they're doing some research, but I don't know how it went from the last in couple of years of that intervention of the OCCE. Okay, thank you, Marit, for highlighting that information. It's important for all the audience and knowing from the inside, the insider trader. I mean, I remember there was a crime that here in the US. I don't know if it's also in India or a part of the world. Its name is called something about broker insider, that if they know something about the money that it's investing and they invest, they go to jail. So yeah, I don't know if it's white collar crimes, but I like the word insider, because you need to know that the information from within. So you and Tony, you're within the system of the ICC, so you have more the information you have is more accurate than many of us. Okay, Professor Milton, you want to say something? Unmute. Okay.
Thank you.
Yes.
First of all, thank you, Dr. Giovanni Marotta, and thank you, my colleagues, the distinguished professors and counsel on this panel. I must apologize for that technical hitch that came through. I've been trying to get the emeritus professor. He's asking me whether is that a sabotage? No, we had a bit of a change. We had to change the title a bit from what we had. Initially, it was victims alone, so we brought in the prosecutor. Now, I would also, secondly, with the permission of the host, indicate that should any of our panelists feel like you have other prior arrangements, because of these technical errors, we are not going to cut short something that's going on, so we'll just not hold you really. We feel very sorry, because we'll continue with the discourse. Whoever feels wants to drop out can drop off, because you can see they're still coming on board. And we don't want to hold anyone really tight here. So if one feels you can leave, it's fine, we shall proceed, but we'll also update you on, it's actually, you can still follow it on YouTube. It's going on right now live on YouTube. You can always access that. So I really apologize for those hiccups. Yes, Dr. Lanciotti, seems you want to say something.
Before closing the meeting, since I didn't have the chance to make comments, I would like to say just a few remarks on the debate, at least on the side related to the victims, which was the original topic of this meeting.
Okay, Prof, just a minute. We are not closing the meeting. I feel you might want to go somewhere. We're just asking whoever wants to leave.
Yes, but
so we give you the chance. Yes.
So it's up to you.
Well,
Otherwise,
let me hand it over actually to Dr. Marotta, who's handling. Oh, he's gone. All right, proceed, Professor.
No, I'm here. I'm here. I was trying
I'm handing
to.
you over to Dr. Marotta to handle.
No, yes, I'm here. I'm checking that everything in my Zoom is okay. So
yeah,
because,
just make sure she gets the opportunity to present before she leaves. That's what she's requesting.
Yes.
Yes.
Yes, because I'm trying to check because I was in another meeting in Zoom, and the system automatically sent me off.
Oh.
I disappeared from yes. So that's what I'm trying to. That is not happen this time. Okay, Professor. Then Shoti, do you want to contribute to the
very quick remarks on what the distinguished panelists have said in today's webinar. Dr. Manpreet Kaur posed the question, who are the victims? And then you, Dr. Marotta, highlighted the problems about access to justice for victims in the ICC. And then Professor Sripatit pointed out that the three main aspects, the three main pillars of the issue of victims are namely access to justice, restitution, and compensation. As for access to justice, I just want to recall that the procedure that has been established in the statute and mainly in the rules of procedure is the result of a big negotiation as usual, and it's a hybrid kind of procedure which takes into account the different legal systems of the world, and therefore it's not so clear and needs some adjustments that only practice can offer. As for restitution, we know that according to a general rule of international law, restitutio in integrum, meaning the total restitution, should be the best way to restore victims of a crime or of an illicit act. However, in the situations of the ICC, that is not always possible. And so we have to think about compensation as a way to make restorative justice a reality. So my question to you, distinguished panelists, is how do we make restorative justice a reality for victims? And because there is, I think, no a single answer to this big question, I have a thought in my mind which I want to share with you, distinguished panelists.
Yes.
Recent situations such as the conflict in Mali and elsewhere have shown that cultural property is at risk not just from incidental harm, but is being intentionally targeted as part of cultural cleansing campaigns. So my question is, can we say that this cultural heritage that has been destroyed, plundered, ruined forever, is a victim of the crimes? And we have to consider that attacks against cultural heritage may fall not only within the category of war crimes, but also in the category of crimes against humanity if the conditions set forth in Article 7 are met. For example, an act of destruction to the detriment of cultural heritage, if committed with a discriminatory intent towards a culturally distinct group, infringes the human rights of the targeted group and can amount to a form of persecution as a crime against humanity. Furthermore, also actions deliberately carried out to destroy religious sites, objects, and other kinds of cultural property that have a great meaning to a particular group of people bound by a national, ethnic, racial, or religious tie may be considered in court as evidence of the mens rea in the crime of genocide. This has already happened before the ICTY in 1 or 2 cases, if I recall correctly. So, can we say that these situations are to be considered in the compensation for victims under Article 75, paragraph 2 of the statute, according to which the court may make an order specifying appropriate reparation to or in respect of victims. This is my point. And I thank you, distinguished panelists, for this and for your attention. And then I want to tell you, at a certain point, the debate went to COVID-19 situation. And I've read that there is a criminal complaint concerning massive damage caused by the alleged criminal actions by the Republic of China and by the city of Wuhan. And this complaint has been brought to the office of the prosecutor by an American NGO whose name is Freedom Watch, Inc. And this is the complainant. Many of you may already know about it. And that was just to share my points with you. Thank you very much to all of you.
Thank you. Thank you, Professor Lanciotti. Well, it's an interesting point, what she has mentioned us about the cultural heritage. If it could be considered a crimes against humanity under the Roman Statute. Well, in some countries, if you damage a cultural icon, in some countries considered a terrorist act. So
there is the resolution of the Security Council about that.
About that.
It could be taken into account to calculate reparation and compensation.
Yes, that's correct. And also, she meant about the because it's as you mentioned, it's like a clearness about the cultural, about the background of an ethnic group. We see it that way. You not only vanish them by killing them, but also their cultural heritage. I mean, it could, in my point of view, it could be integrated to that as a crime against humanity. So, and also we have what happened in the past with specific ethnic groups during World War II under the Nazis. What they destroyed the Roma people. They were trying to not only to disappear them, but also to disappear the cultural heritage, and also what happened with the Jews. And I mean, it's important that in some point, what Professor Lanciotti has told us could be considered the wiping of these monuments to history. It's also, I mean, it's the soul of, I think it's the soul of a group of people. So also it should be considered. And the way I think Professor Lanciotti told us about related to compensation, how to related to the how
restorative justice.
Compensation of justice for the victims. I was thinking, and that can help us if she's here with us. Yes, she's here with us, Victoria. I mean, for example, what comes to my mind is the Inter-American Court of Human Rights and Inter-American Commission of Human Rights. How they, I mean, if you try to surf their webpage and you see, for example, I know Uruguay versus
Paraguay had some cases.
Yes,
with the,
cases, and the court, yes, and the court and the commission has ordered for this compensation, not only, I mean, for example, for this group of natives, I think was in Uruguay or Paraguay, I don't remember where. That
two cases were in Paraguay.
Correct. Yes.
And then also Uruguay, but those in Paraguay were the leading ones, if I recall correctly.
A short interruption.
Yes.
Oh, short interruption. Sorry.
Yes. No.
Distinguished
yes,
professors, here we connect Dr. Frimpong. But just before that, I mean, Professor Emeritus, Professor Dr. Lanciotti, allow me, I want to have a word pushed out so that before the Professor Lanciotti leaves, at least there's something I've pushed out, which I felt was very critical. Welcome, Professor. Welcome, Professor.
Thank you very much. After the torture. Yeah.
Apology. Okay, Professor Dr. Lanciotti, you mentioned very, very critical points, and I fear you might leave before I just say a word, which I feel you should give emphasis to. Very, very critical, and I think this reinforces what, can you hear me?
Yes.
Okay. The issue of hybrid system, I think during your time at the conference, it must have been one of the issues that you took very, very seriously, because you have a continent with hybrid, legal systems in place, the Roman Dutch system, because even as of now, right here down in Africa, we have places where there's Roman Dutch system, there's a common law English system inherited. As I told you, I did the New York law course. We have a lot of law, actually common law practice in New York State. So anyway, in short, what I'm saying is that's a very critical point that I feel at some point in future we need to address. The time does not allow that at all. But I want to thank you for raising that, Professor Dr. Lanciotti. It was quite a valid point. The other point I saw that I felt it would be disservice if I don't raise before you leave is the issue that talked about, you posed a question about restorative justice. And you said this question was really a big and bold question that you felt one would answer. That is another very important point, professors, that I think we will look into in the fullness of time. And I would also want, before you leave, you might leave before us, I've done lectures. I have a series of lectures I do on international criminal law. My lecture 7, if you'll have your free time, you go to my YouTube. Lecture 7 deals with victims and the International Criminal Court. I would urge you to listen to it, and probably it would form a basis of some comment from you at some time. Usually I give those, I have a series of lectures, you can find them there, or you can find them on the website icrjustice.org. That's also for the viewers, millions of viewers outside there. What Professor Lanciotti was touching today before he left, and also what Professor Sripathi, there are areas where Professor, I'm not in a rush because I know it's hard to release, but I'll also touch the number of areas Professor Sripathi touched as well, which need to be re-emphasized. So I really respect your contribution. And as I said, the way you posed this question is the way I pose it to my students. When you asked us a big question and you said not even one could answer it. The point is, when I address issues, there are themes like what, who, why, when. And I always emphasize that in law, actually, my best law student, I usually give them 8 out of 10 for the best argument to the answer. You may argue your way and get a wrong answer. You only earn 2. So we inculcate the legal mind. Thank you very much, Prof. Thank you, and back to Dr.
I have one last point.
Yes, go.
Actually, a question I would like to ask the panel and leave it at that. Now, Professor Lancelotti had spoken of restorative justice. Now, restorative justice is possible in most of the crimes. Victims can be helped, but not in the case of rape victims.
Yeah.
Because what can you restore in the case of rape victims? Can we help them? What are we going to restore? That is my question.
Good question.
Good question, Professor. Well, yes, I was here with Professor Lanciotti. We were.
I didn't hear the question because
yes,
there was some noise. Pardon me, Professor.
Professor, I'll repeat. I will repeat, Professor Lanciotti.
Sorry.
Restorative justice is possible in most of the crimes where, I mean, if a person loses property because of some crime, property can be restored. But in the case of rape victims, I feel restorative justice is not possible because in the case of a rape victim, the victim loses a chastity. Can we restore that?
No.
So that is what I'm saying.
No.
What are we trying to restore?
Prof, that's why we are saying
restorative justice is not possible in the case of rape.
Yes. You are
That
very
is
right,
what
Prof.
I would like to say.
That's what I was saying. That is why the way she posed it actually provokes thought. That was the main thing I was trying to say there. Okay then. Dr. Marota?
Yes. Yes, what I was trying to make the approach related to compensation. I was posting and mentioned the Inter-American Human Rights Court and the Inter-American Commission. I mean, they started back in the 50s, 60s. I don't recall. So, I mean, there is a lot of their jurisprudence related to compensation, victims' compensation. Professor Lanciotti was mentioned the case in Paraguay. It was, I remember I have in one of my international classes, a professor mentioned that it was a group of, it was a paper. I think it was not the paper one. It was related to an Aboriginal group of Paraguay. They filed their case against, because it was related to property, first to the commission, because the Inter-American Commission has the function of a prosecutor office. And then they pass it to the court, and they have a money compensation, and also they have other kind of compensation that was related to the final ruling. You can check it. The ruling, I mean, the rulings in the Inter-American Court of Human Rights are in Spanish, English, and I think also in French, because they're the language that they handle in Latin America. And that's why the reason I was trying to. We can see how in the last 50 years. The Inter-American Court of Human Rights has handled the compensation of the victims. Also, in cases where there have been crimes like as torture or even crimes against humanity, there is, I mean, here Professor Renzo Canedas, between the military coup in Argentina between 1975 and I think it was 1986, how the cases, if she have the information about if there were some kind of reparation from Argentina to the victims during those dark years from the Inter-American Court of Human Rights. Do you have that information at hand, or? Because, I mean, there was a military regime in your country back in the 70s, mid 80s, I think. It was during also the War of the Falkland. And also in Chile. In Chile, they also have a military regime the same years of the Argentinian. I don't remember which was first. It was first the Chile or was first but if you see, they have the same similarity procedure of violations of crimes. I mean, there were some pronunciations of the Commission, of the Inter-American Commission, and also from the Court of the Inter-American. So, did your government, because I'm asking from Argentina, did the compensation to the victims? Because I think there were some cases in the court. Do you have them?
Yeah. Yes. There are so many cases. Victims have a compensation of the familiars of the victims have a compensation. Obviously, it's a monetary compensation, but as before Professor Lanciotti said, that a real compensation? I mean, if we compare what they suffered, we could think that there is never a compensation to all the damage that they have.
Yes.
But yes, here it was punished. But you know, Argentine, as a lot of others, Latin American countries, we have a very weak judicial system. There are a lot of, we delay a lot of time in have a fair sentence, and when we finally got the sentence, maybe the accused are 70-old people, so they go to their house, to home, to continue the punishment. So it's like we have this feeling that it's never really compensated. You know, that they just don't have the pain that they should have. That is the feeling that we have about all those crimes, and it was the 70s.
Yes, that's
1970. The war.
Yes, that's correct. Yes, that's correct. Because I recall, because I have some friends that they are. I have some friends that they were adopted, and they were the born children of I think it's the grandmothers of Plaza de Mayo. And those days, yeah, something, yeah. And I know I studied with. I have a friend in the master that he was one of their biological fathers. They disappeared. He's from Spain. Well, he was adopted by a Spanish family, and but he's in the relation of the grandmother's webpage, Plaza de Mayo.
Yes, grandmothers and mothers. There are both groups.
Yes. But I think now because the years have passed, and now they are grandmothers, because they consider that, and yes, we studied with him, and I think he was one of the first to be, when it appears the DNA testing. He was in the first group of that. So yes, it's as you have told us, sometimes the justice comes later, because the perpetrators, they are probably old people. They could be your grandfather or your great grandfather or your grandfather. Okay, thank you.
Yes, Dr. Marotta, sorry for disrupting.
Yes.
Yeah.
No problem. Yes,
I would like to interrupt and apologize profusely to our two panelists whom we are just looking at. We are Professor Dr. Kwame Frimpong, who has just arrived now, because owing to those technicalities, he says he was late. And we have Dr. Dita Barantsane, who is, I said, Director of Legal Services in South Africa. Both of them are in the house, and probably they might want to engage with us going forward as well. I just wanted to introduce that they're in. Thank you very much, Doctor. I know we are way past time, but we can now try to expedite and curtail on the time we have, at least to accommodate whoever might have missed out. Back to Marota. Thank you.
Thank you. Welcome, Professor Ditaba, to the meeting. I know that you have some technical problems as Professor Frimpong. Well, I think it's sometimes, I think also it's for the timing in some parts of the world that is earlier, and a lot of connection is going on around Zoom. So many are doing their classes, and so sometimes it's very difficult, the connection. Well, continuing with the...
Thank you very much, Doc.
Yes, thank you. Continuing with the points of compensation of the victims, as Professor Lanciotti mentioned, who else wants to share something that brought Professor Shipati related to, I think, what's rape victims? If there was some kind, we agree that there is no restorative justice against rape victims. So in an international context of international crimes, that is also in the Rome Statute as a crimes against humanity, rape of women and children. How do you think the restorative justice?
Dr. Marota, let's make some clear there. I think there could be some misunderstanding somewhere there. When we talked about restorative justice, that was raised by Professor Dr. Lanciotti. It was not supporting anything, actually, for that matter. I was saying such provocative questions are useful because they bring us to think wider.
Correct.
But I think in the ultimate analysis, we all know that crimes that apply in the context of victims must ultimately draw from Article 5 of the Rome Statute. We all know that. So I'm not sure that I wouldn't want to appear like when I made a statement, I was actually advancing certain line of reasoning. I just wanted to know the kind of question, because the part I liked about that question is she answered and said, this is a very difficult question to address, and so threw it back. So I wanted that clear, because there's a possibility it could. All the crimes we know boil down to Article 5 of the Rome Statute. And that ties to what Council Manrit also mentioned some time back when we talk about those crimes. It boils down ultimately, because who can commit those kind of crimes? Are they individuals, institutions? Those are provocative questions. Those are the ones we want, actually. That's all that we are saying here. So people should feel free to debate widely, not to confine ourselves, if you don't mind.
Yes, no, I was trying to finish
other topics so that we can wind up.
Yes, I was trying to make it close into the point of Professor Lanciotti.
Yes.
So
yes, that's right,
Prof.
That's fine. Back to you.
Yes, Professor Frimpong, you was trying to tell us something.
I wanted to say something briefly on the point raised by Professor Shipati concerning restorative justice in the case of rape victims. I don't think it is only in the case of rape victims that there is no restorative justice. Because if you are looking at it from even the old notion of eye against eye, tooth for tooth and all that, how did we address those cases if, assuming for purposes of discussion, somebody were to have removed one tooth and the person is toothless? How would you be able to get that kind of restorative justice? In all those cases, the solution lay within appropriate compensation, not necessarily in all cases that you give tooth for tooth. So even where you have rape or some types of crime that could not be appropriately compensated in terms of the same restorative justice, we look for something which is comparably acceptable. I I'm sure Milton may remember there was a notorious case in Botswana years ago when some boys raped a young girl. And traditionally, the question that the headman posed, would you be happy if we shambok the boy?
Yes, I recall, Prof, very well.
Thank you very much.
The
question is,
I recall in your class.
Would you be happy if we shambok? The girl said, yes, I have no problem.
I recall in professor's class, we are always ready to have a shambok. He would always tell you, I will shambok you. That's about 15 years ago.
Okay, that from the girl's point of view, the shambok is sufficient restoration of her in quotes.
Yeah.
But if we are using the normal concept of justice, obviously not. So as Milton will continue, eventually when the father heard that the boys had only been shambok, she said, what? You raped my daughter and only shambok? So he went for a further appeal in the case.
By the way, a shambok is you know, for those,
yes,
it's a whip. So the professor would always come in class with an imaginary whip.
My friend, you are exposing me to international criminal court, okay? I don't want them to prosecute me for shamboking students. Yeah, so the point I'm making simply is that even if there is no appropriate restoration, we can look for something comparably acceptable. Thank you.
Thank you.
Thank you.
Justice.
And thank you for reminding me.
Thank you, Professor. Yes. Thank you, Professor Frinton, for the example. Very illustrative. Yes.
I have had professors, but there's only one class that everybody was always willing to rush at. You would leave with stitches, stitches. Okay, thank you, Doc. Proceed.
Thank you. Well, anyone else to want to contribute with the debate that we are having right now?
Thank you, Prof. Doc.
Thank you.
Maybe I can also add a word or two, and outrightly state that the topic on the table today is very interesting, and I'm quite passionate about the victims of crime for obvious reasons. That for 12 and a half years I was a prosecutor. So what I realized about the criminal justice system, the structural formation of the system always left the victims outside. Because probably of history, how the criminal justice system evolved from the time when the victims of crime were in total control of the system if they are violated, until it went to the 19th century, whereby the state now became the complainant. And in the process, the victims of crime became what we can call the forgotten persons by the system. They became only the tools that are used to achieve justice, not necessarily the main focus of the system. Now, when you go to the international level, obviously we talk about violation of human rights, and whereby the complaint will be against the state, as opposed to the national level, whereby it will be against a specific offender. Now, the topic raised was how can restorative justice be applied, and I would ask myself as to, at that level whereby people are raped and their rights are violated, how do you achieve at least an appropriate restorative justice process or an appropriate compensation. I think Prof. Frimpong unpacked it quite nicely for me and answered some of the questions that I've been asking myself in my own corner, at my own space, to say, can we really, if it's at a national level whereby as something has been stolen, we can easily apply restorative justice, but at that international level, how can we achieve that? But now, when he unpacked it, he gave me an idea that you don't really have to look for exactly the same type of a compensation. Look for an appropriate compensation that will still satisfy the objective of the restorative justice process. So I think internationally, we have instruments. As back as 1985, the General Assembly had already put together an interesting instrument that will ensure that it enhances the role of the victims, it protects the victims, it talks about compensation, it talks about assistance. So I think at times, the question is, how effective are these instruments? Because they can be a very good piece of instrument or measure that is put in place, but I realize that how it's packaged really contribute quite immensely to its effectiveness. I'll make a typical example about in South Africa, we've got the Constitution, which we say is the supreme law of the country. So if which it's the supreme law, and all other laws are subordinate to it. So if you take the rights of the accused and you package them in the Constitution, and you take the rights of the victim and you package them in a victim's charter, which is an instrument somewhere in the corner there, obviously the rights that are in the Constitution are going to be supreme and more protected than the rights in a victim's charter. So at the end of the day, if we have instruments, the critical question is, how do we package them in such a way that they will be effective? I think that is basically one of the critical questions that I always say we should ask ourselves and say, are they properly packaged in such a way that they become effective? Thank you very much, Chair.
Thank you, Dr. Ditaba, for your excellent presentation. Okay. Well, I pass the text to Professor Milton for some points he wants to bring on the desk.
Dr. Marotta, thank you very much for that erudite presentation. And I want to thank Dr. Ditaba too for that last minute drop-in, and as well as Emeritus Professor Frimpong. It's always nice to see people who have produced thousands of lawyers get back to us, and we join, and still we're able to drink from the fountain of wisdom liberally, as it were. You know, it is quite encouraging. I want to thank all the panelists for now. I'm not sure how the direction of the debate. I decided that the discourse would be totally handled by Dr. Marotta. So, but in any event, I think so far everything is heading well. As I said, it's very critical. I've covered in one of my full 1.5 hour lecture on one of my lectures. I have a series of lectures I conduct on the international criminal law. I've dealt with the topic of victims in a broader way. So our viewers, wherever you are able to access this. Though it was live streamed, you simply have just to go to YouTube, Prof. Dr. Milton, you should be able to get lecture 7, or you go to our website, icrjustice.org. There'll be something I talked about on the victim. But what my colleagues are talking about here, actually not covered there. It has gone so far beyond what is covered. like I've learned the interesting debate of that has been introduced by both Dr. Sripathi, who always has a dimension of virtually everything we do have here and encourages us to move on. How the emeritus and the Dr. Sripathi have dealt with the issue of restorative justice and how you have reinforced that, Dr. Gitaba. It's very interesting to hear such intellectual debate going on. I know we didn't plan much. This was a very interesting area. We didn't plan to get this far. But for those who are not here, the professors, we started off by acknowledging, having a solemn acknowledgement of the loss we've had over time. I explained why actually there's not so much excitement about achievement of the ICC at our last meeting. And our colleague, dear friend, Council Manrit, brought up the 7th of July date very, very appropriately. It was such a nice reminder. But we said we've actually lost. If considering Rwanda alone, we lost 1 million in just a couple of weeks. And we've continued to lose lives. So we thought it was an appropriate time to instead make a solemn recognition of the loss. Not only as victims, some of them were lost as victims, but we have those who have died in the fight against impunity. So all these deserve recognition. And I said there's still those dying during this time of COVID-19. All of us are here at a time when people are busy, confined, but we are able to recognize that we need to go on, life must continue. So we recognize everybody and the sacrifice that is coming from all of us here. And I thank you very much. This is what made me, I was in the hospital admission, but I was able to address from the hospital because I could see around me those who had complications that God has spared us from. So I really want to thank you so much, but I'll not leave the closing, and I'll leave it up to the host. Thank you so much for being part of this. And I would encourage you to listen to that particular lecture. It brings in most of the points we discussed also, so that the next lecture topic would be announced by the co-host. I think maybe not now, but we'll see, unless he has it ready. If not, we are going to have a mechanism through which we are able to reach you. So thank you very much. Thank you so much. I appreciate Dr. Marota, and thank you, professors. It's been really a pleasure having you around here. And we are sorry we got your intellectual inputs late, Professor Frimpong and Professor Vitaba. Thank you a lot. It's always a reminder that if professors like Professor Frimpong can withstand the test of intellectual time, then all of us who are his products and many others will do the same. Thank you. It's always an inspiration to see you. And we can see Professor Lanchot, who also attended the battle at the beginning. She was actually at the front line. We are just coming with the boots at the back. They were in the front line of the International Criminal.
I had to meet somebody, so I skipped the last part. But I wanted to say goodbye to all of you.
Yes, that's right. So we said goodbye together as one. It's good that you're back. Thank you very much. Yes. And
thank you.
Thank you.
MILTON.
I leave it out to the director, to Dr. Marota, to wind it up in style.
Yes. I wanted to ask a simple question. Dr. Marota, can I?
Yes. Yes, of course. Professor, you have the desk. You have the floor.
Since we are discussing the issue of victims, don't you think that since the professors have been victimized in this particular episode, you should also be compensated?
Very good.
We shall send the drone.
Thank you, Professor.
Thank you, Professor Frampton.
May the Lord keep you longer. Thank you.
Thank you. Thank you, everyone.
Thank you.
All right. If there's nothing else, bye-bye, our viewers all over the world. Bye. We'll see you again next week. We'll announce the next topic tonight or tomorrow.
We're going to announce the next topic.
Bye-bye.
Bye. Have a nice weekend.
Bye.
Thank you. Bye.
Bye. Thank you.
Bye.